Now, the reason why CBS's TV show Bull exists is more for entertainment. Luckily, they actually do a pretty good job dealing with some issues related to the jury. It is an entertainment show, so it does go off the rails at times and is unrealistic in its portrayal of what lawyers, trial consultants, and judges are allowed to do. At the same time, it deals intelligently with issues such as bias, such as juries as fact finders, and other issues that we'll talk about today. So we thought, as the Civil Jury Project, that it would be a great idea to have a panel to discuss the show. Today we are lucky to have Stephen Sussman, who is a practitioner. Steve serves as the executive director of our program, the Civil Jury Project. He's one of the country's most successful trial lawyers. 40 years ago, he founded Sussman Godfrey, the country's first commercial litigation boutique, specializing in representing plaintiffs on a contingency basis in complex business disputes. In addition, we have Roy Futterman, who is a trial consultant here in New York City. He is the director of the Doors Trial Strategy Consulting Group. He's also been writing a column on the TV show Bull called Talking Bull, in which he talks about some of the issues we're going to discuss today. And we have one of our professors here at NYU, Professor Christopher Robertson. He is visiting here at NYU, although he is the Associate Dean at the University of Arizona. His research focuses on the way lay people make difficult decisions, including patients making healthcare decisions, and his work has been published widely. So just to give a quick idea, I thought I'd play a clip for us to introduce us to the show and sort of what we'll be discussing.
Our system says a man is innocent until proven guilty.
Innocent till proven guilty. Nobody believes that. Show me where that's written down. It's called innocent till proven black.
I believe in our system of justice.
How many people have been taken off death row because of DNA testing?
20. It's 20 people. 20 people who
Blaming
have
the
died.
system. There is a better way.
Rich people don't play by the same rules.
So that's our system, a cacophony of voices trying to arrive at an answer in very difficult situations. That's what the jury is. And the way that we draw upon those people speaks a lot about how our system works. So sort of the format of this event is going to be a clip that'll introduce a topic, an idea about the jury, and then our panelists will discuss it. So, oh, I already did that. So in this next clip, we have a discussion. The show is dealing with the role of narrative in trial, in creating a cohesive approach to a trial. This episode involved a bomb that had gone off. It doesn't matter. Listen to the things. You'll understand once it starts going.
We all experienced a trauma today. I have to admit, when I heard the first explosion, I thought I was dead. When I heard the second one, I was at least happy to know I was alive. I don't know if we all had the same experience. Who thought the first explosion was the loudest? I see. And the second? And does anyone here think there was only one explosion? Move to strike, Your Honor.
You are excused.
Thank you.
There's only one explosion.
Yet no one on our jury is sure of that. They're all hearing the second one in their heads already.
Reconstructive recollection, Bull?
This case hinges on memory. Memories can be altered by time, by repetition, by any number of factors. You want a jury who trusts Danny and her memory, and I want a jury who trusts neither Danny nor her memory. That's how I'll depict Danny. Best narrative wins the case, but only the truth will set us free. Okay, that's one way it could have gone. I just shaped a narrative to get specific people to believe a specific version of reality.
So I think the key line in that clip was best narrative wins the case. I don't know if our panelists would agree, but that's a very interesting idea and approach to trial. Most episodes actually show Dr. Bull and his team studying and cultivating these narratives to inform their approach to the case. So my question for the panelists is, how much does this ring true to your experience or your thoughts? And do the facts matter, or is it really just who can construct the best narrative? Maybe I'll start with you, Roy, since you do work as a trial consultant.
So one of the nice things that Bull, the TV show, does is focus on this issue of creating a narrative out of the facts. Right? There are many wacky things, as you'll see as we go on, many wacky things that the Bull show does, and many sort of outlandish things, whatever. But there are some things that they do very well in the show. One of the things that Dr. Bull and his team does is they do a lot of mock trials where they try out different versions of the same story. They take the facts and they tell the story in a different way and see how it plays out with mock jurors. And they do it in a strange way, but it's pretty much what we do in the life of jury consulting, where we run mock trials, and if you run multiple mock trials and you tell the story a different way, you get different results. And it is very, very true that we see that, right? That you don't just see the same reaction every time. Yeah, the short answer is yes. When you take the facts and tell them in a compelling narrative, you're halfway there.
Steve, what do you think about that? As a lawyer, do you think that constructing a narrative is more important than the facts?
Absolutely not. If I did, I wouldn't be doing it. You have to believe, I mean, I've done it enough to believe that the facts, if you can get the real facts, you can get to the truth. And the jury will figure out what that is. I represent a lot of big companies and rich people in cases involving hundreds of millions of dollars. I've never conducted more than one mock trial per case. It's too expensive. It costs like $50,000 to do one, usually. And the kind he's on Bull that you're seeing would cost $150,000. I mean, it's a very expensive exercise. So the idea that you can keep telling the story in a different way and get a different result, I don't believe it. I've never been able to get a different result by changing the way I tell the story. You know, the advantage of jury consultants to me are, it does help you improve the arguments you make, because there's a way you can communicate that's, you know, you can learn to improve your communication style. But I don't think you can, you know, I don't think you can put lipstick on a pig and change the narrative so much that it's going to change the result. I really don't. And I just think that that's why the show is crazy. And I don't like the show because it demeans jurors' ability to see through the truth. I mean, my view is that it doesn't matter who your lawyer is. It doesn't really matter who your expert witnesses are. It matters what your basic facts are. And that's why these mock trials, that's why I'm paying a lot of money to people like Roy, because it also, what it does is really tells me in advance of trial what the likely outcome is. What you do in these mock trials, you get 36 people, maybe 3 juries, 12 people each, or you could get 4, however many you want, and you let them deliberate at the end to a verdict, and you watch their deliberations over some closed circuit TV. And, you know, if 3 or 4 panels come out on your side, you're likely to win the case. But if you get 2-2, I think you're in real trouble. And you can't really change it very much. I've never been able to change it very much. I think it's very accurate, which is why I keep paying people like you to do it.
Chris, yeah, what do you think?
Yeah, a few themes I'd draw out. First, this already suggests 2 potential roles for a jury consultant. And one is to help you shape the way you present your case, to try to create the right narrative or try to get the facts stitched together in the right way. And the second potential role is to help you select a jury, help you get the right people on the jury to make a decision. And I think Steve suggested a third role is to just give you a preview of the likely outcome of your case, which is then useful really to decide whether to try it at all or instead settle in. So it's useful to, I think about those 3 different functions, and consultants may add value in any of those 3 dimensions or none of them, depending on whether there's anything there. I'll say, and then to speak to some of the methods we've been using growing out of our academic research is where we'll actually get, say, 1,000 people to respond to a case online. and actually randomly manipulate a version of the case or not. And in a sense, agreeing with what Steve said, it's very rare to see anything matter than more than about a 10% verdict rate on the margin. It's really hard to beat up the case enough that you shift jurors more than about 10%. On the other hand, if it's a $1 billion case, shifting them by 10% is actually, shifting the chance of winning by 10% actually has some real value. So I think both are true. But I think there is something to be said about systematically trying different versions of the case.
Oh, and I think it's also useful, I do think it's useful to, I mean, it is useful in jury selection, or rather jury deselection. You know, you don't pick the jurors you want, you get rid of the jurors who are terrible for you. That's the key. And you have peremptory challenges, and you can exercise, it depends on where you are. In federal court, you get 3 peremptories in a civil case. In many states, you get 6 peremptories, but, and you can, those are just jurors you want to get rid of because you think they are going to be too strong. You can't, they're already made up their mind. So, yeah, I mean, to get rid of, and particularly where the jury verdict has got to be unanimous, it is helpful to figure out, to try to get rid of people who you know are just, there's no way you're going to change their mind, no matter what you say.
The deselection of the jury is a really interesting aspect that the show, I think, deals with in every episode, and also the subject of the next clip, as that is one of the main of the 3 that Chris mentioned, jobs that trial consultants do. So let's watch this next one.
The jury starts with a preconceived idea of the truth. We don't guess at that.
We deep dive into the jury pool.
We know what they're thinking from the beginning.
What happened to innocent until proven guilty?
No trial starts at 0.
Even before jury selection, TAC profiles every potential juror.
Their behavioral patterns, in life and especially online. What they click on, likes, keywords, avoidances. It all gets plugged into a 400-factor matrix that is scary in its predictive efficiency.
We'll know how they'll vote even before they do.
How do you get that data?
I hired Marissa from the Department of Homeland Security.
Is there someplace we can sit?
Sure.
So, what are they thinking?
You're a rich jerk. He's your jerk son who got everything handed to him.
A trial is not a popularity contest.
Good, because they don't like you either. Speaking of which, I don't want to see this army of lawyers again. Just you and her.
I've tried hundreds of cases without this woo-woo psychology.
So what would you do?
No eyewitness, no murder weapon. Those are the facts. Try the facts.
Except we already tried it 18 times on the facts, and we didn't win one.
Well, a mock trial is not a trial.
Innocent until proven guilty is like 2 all-beef patties, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. It's the old jingle.
So that kind of exemplifies some of the points we were making right now about selecting a jury that is going to be receptive to the narrative that is being constructed or that is being chosen, perhaps swung by as much or as little as 10%, however you want to paint that. But it also brings up another issue about deselection of juries, which is that it can lead to a form of discrimination rather easily. We look at the veneer and we figure this type of person is going to believe this type of thing. We look at their Facebook or their online presence and we say, if they have 3 dogs, they're more likely to think this or that. The show uses this aspect constantly. They'll say, I know that this person is going to decide this because of this factor. That can lead to a form of discrimination that maybe we aren't willing to accept and can cause its own problems. Is there anything that we can do about that, or is that just the state of affairs when we are deselecting a jury?
Well, you know, we live in a world that has tremendous amount of information available about all of us. And there's no such thing as privacy anymore. I mean, we are all over the internet, and our presence is there, and you can find, I mean, now everyone does this, and it's permissible. If you can get the list of the potential jurors in advance, which you frequently can, You immediately Google them. There are various ways. I mean, Roy can tell you what services he can provide, but a lot of jury consultants can tell you whether they voted, which party they voted for, Democratic or Republican, the neighborhood they live in, how much their home cost, what's on the bumper stickers on the cars in their garages or in front of their homes, what churches they belong to, all kinds of activities about them. And in cases now, both sides are using extensive questionnaires to get information about people, and then you can use the internet to research quickly. So, yeah, I mean, and then, you know, you ask someone like Roy, well, prepare some matrix. That's a great thing when it begins with this I've never used anything like that. That would cost probably $1 million. But someday we will, I mean, I have no doubt that someday we will get there, that you will get a jury list of people and you have a scanner in your courtroom and you put it in the scanner and it goes to some internet connection immediately. And you've already told them, already sat down with the people and programmed in the algorithms that you want to look at and how much you're going to weight them. And it comes back in like about 10 minutes, ranking the worst jurors for you. I mean, that's what you'll do, because you always begin there. It'd say, who's worst on this group? And you exercise your first peremptory. And who's, well, I would say, and I think this is probably true, if you get 6 peremptories, 4 of them you can know without having to do anything like that. It's the last 2 that you always have problems with figuring out, because it's not so clear. 4 people will be obvious. You've got to get rid of them. And then we're going to be arguing about, how about the next? We got 2 more strikes. Who do we use them on? And maybe something like this would be helpful. I think it's fine. I don't think there's anything wrong with it. The information's out there. And I think that's fine. Now, you know.
Well, maybe the idea of selecting a jury is to pick one that is not going to be biased, rather than maybe trying to pick a jury that's going to be more favorable. What are we trying to accomplish through this? Do you think, Chris, do you think something along those lines? Or?
Just to go back, before this idea of big data became so hot, there was a lot of thought that you could select a jury based on demographics, that, you know, white women are going to be good because my client's a white woman, or because she's a rape victim, and the white woman will feel sorry for her. But the research suggested that it was never that simple, actually, that sheer demographics had very little predictive power. And sometimes they had predictive power in exactly the opposite way you suggested. The white woman was critical of the rape victim because of this or that, and the narratives that people told were always much more complicated. And so I give that as background because I'm not confident that the big data revolution is really going to help much unless you know the link between those predictor variables and the actual outcome of interest. So unless you know that bumper sticker type X is actually correlated with the particular trial outcome in this case, I don't think that's actually going to get you much. You can have a lot of data about people that are actually trivia when it comes to predicting their decision in the given case itself. So we've tried using, so I think you actually have to marry big data to outcomes on the case in particular. And so we started doing that in some of our research. We'll take a pending case and we'll make up our favorite 50 voir dire questions. And we have to pay people a lot of money to respond to 50 voir dire questions and then actually respond to a case stimulus customized to this case. But when you do, it turns out that only 3 of them were actually very predictive. And the rest that you thought, gosh, it sure would think that if this case is about a police officer having a family member in the police, well, that would be really predictive, but it turns out it didn't predict at all. So I would just be careful of using big data married to your hunches about why it matters, because garbage in, garbage out, you actually need both links. The data about the individual jurors linked to data about how that causes a response to this case in particular. Otherwise, I think it's a lot of flash and bang that isn't really getting us much.
Roy, what do you think about that?
This is the big booming area in the jury consulting world right now. People are saying we will research your jurors, we'll use AI, we'll use deep learning, There's a lot of technology companies who are creating things. They're saying, they're coming to us and saying, well, we can use this to do very rapid searches of everybody's social media postings, et cetera, and get all this stuff. we're not there yet. We're certainly not anywhere near what Bull is trying to say. And, they use somebody from Homeland Security. But so we're not anywhere near yet. It may be that 5 or 10 years from now, it'll be a matter of course. It's becoming more of a matter of course for lawyers to request for us to be doing a minimal amount of Google searching. Now, how effective is that? People nowadays, if you look at where we are now as to even just like a few years, 5 years ago, people are much more knowledgeable and matter-of-fact about setting their privacy settings correctly. So you're really only finding outlying information. If you're a member of, a hate group, you probably know how to set your privacy settings. But you are looking for other outliers in various aspects, and it may be something that is socially okay, and you will find it. So I think this is a question that sort of needs to be on hold, and we'll see where it goes into the future. I think that right now what we have is the adversarial system taking care of a lot of this, where people are choosing against each other and therefore pulling out the extreme people and getting us more towards the middle.
The one thing I get from academics around the country who have studied juries is the question of why do we allow peremptory challenges in the first place? Why do you allow a guy like Bull even to do this, to try to tell you who to strike or how in picking juries? It's okay to get lessons. He's a pretty good lawyer coach, actually. A lot of the episodes indicate what he's doing is he's coaching this bad lawyer who works for him. How to perform in the courtroom. Sometimes he gets up and performs himself with it. It's totally unrealistic. But, some academics are saying we shouldn't have peremptories. We should just take the first, the first 12 people who are qualified and not be able, you could challenge them for cause. That's fine if they say they can't be fair or they are related to someone or they own an interest in something but we should eliminate peremptory challenges, and it's they may have a point. I'm not sure where I come out on that.
I think they do have a point, but it's because juries are too small to be statistically representative of the community. As a social scientist, I solve the problem of outliers by just having a lot of people. If I was interested in New Yorkers' views on Proposition X, if I went out and surveyed 12 of them and tried to publish that result, I'd be laughed out of the room, right? But that's what we do with juries, and so I think the solution for outliers, meaning that you could just unluckily get a bad 12, is we use peremptories instead. If we instead had larger juries and non-unanimous voting rules, then peremptories would be unnecessary.
If you didn't randomly pick those 12, but you selected them by what type of clothes they were wearing, you would also be laughed out of the room, though. Right? If you wanted to know what 12, not random New Yorkers found, but the 12 wearing red shirts, because red means something.
If the two options are either get a true sample of 400, or that's random, or take a random sample of 36 and deselect who we think are outliers till we get to 12, that may actually be better than merely taking a random sample of 12 because of the risk of outliers you would get. So it's the deselection paired to randomization might get us close to reasonableness.
That's actually going to bring us to the next clip too, because sticking on this idea of why we dismiss jurors or deselect them is because we are afraid of jury bias. We do this for cause, which we anticipate there would be some type of bias, but through peremptories we do it because we think that there's going to be a bias issue. So in this next clip, we have a case in which Bull was handling a trial for a pilot who had recently been involved in an accident, and she was being held liable for the injuries. And they had found that female pilots were being held more liable than their male counterparts. So this has to do with that form of sex bias.
Now bear with me. I'm going to show you 3 pictures that tell a story. Okay? Here we go. Now, as you can see, these kids are getting bullied. But then one of them fights back. All right, here they are. The principal's office. And here's the bully, nursing his black eye. Okay. Now, as a show of hands, what was the color shirt of the kid who confronted the bully? Was it a blue shirt? Okay, well, let's take a look, see if we're right. If y'all guessed blue, you're wrong. The kid who confronted the bully was wearing a red shirt. See, I never specified which kid confronted the bully. You all just assumed it was the boy. Now, come on. I admit, I failed the test too. You see, it's hard to imagine a girl being the hero of the story. Just like it's hard to imagine Captain Matheson being the hero of the one in this court. She is.
So it's very important that we try to combat jury bias. I'm not sure the best way to do that is in closing arguments with like a mind game, but what are some of the ways that we can try to combat it? We talked a little bit about voir dire and deselection of juries, but what are some other approaches that practitioners can take to try to weed out this sort of, one of the weaker elements we might think of as of the jury?
One thing that the courts already do, and they put a lot of faith in, is just asking jurors if they can be fair and impartial. So traditionally, we talked about preemptory challenges, but with challenges for cause, typically there's this dialogue where you find some reason why the juror might be biased. They have a cousin who is a doctor like the defendant, for example, or they know the prosecutor socially or something. And so you ask the juror, well, given that fact, thank you for disclosing it, could you nonetheless be fair and impartial? And almost always the juror says, yes, I can be fair and impartial. It's kind of like my duty as a citizen. And prior research has shown that their answer to that question about whether they can be fair or impartial is then the best predictor of whether the judge will leave them on the jury or not. And so I call this a self-diagnosis. We ask the juror to self-diagnose whether they can be fair and impartial, and we've tested this empirically and found that the answer to that question is completely useless for predicting whether people can be fair and impartial, because a lot of bias, really the whole point of bias, as opposed to hatred, hatred is cognitive. I'm going to get that person, but bias is implicit. It's something we can't control, nor can we self-diagnose. So to answer your question, this is one thing that practitioners do that I think is completely unsupported by either psychological theory or empirical evidence.
Right, so I mean the issue of implicit bias is that it is an unconscious mechanism, right? So it's something that you yourself are not aware of, that you have a bias. And so it seems like the way to deal with that is also on an unconscious level. If I may be so bold and act like a psychologist, one of the ways to do this is to think in advance, what are the likely implicit biases that someone might have in this case? Right? So suppose your defendant is me, it's a husky fellow. So you say, okay, so what are people going to think about a guy who's fatter than others? Are they going to think, they might think, oh, this is somebody who has no self-control. This is someone who has no willpower, right? Well, they may or may not think that, but if you assume that in advance, you may then use your opening argument to make some sort of education about willpower, etc. You may educate people as if you're dealing directly with their implicit bias. It may or may not work, but it's a way to sort of, you clue in advance and attempt to educate around it.
Yeah, I think another thing which you can do is, I mean, in those jurisdictions where you're allowed to ask, lawyers can ask questions in jury selection of the jurors. You ask them questions that are designed to bring out what they feel about certain issues. In the case with no facts, they didn't have any facts, so they're going to be in favor of the person who comes to court or the person who's defending themselves. Or they don't tell them any facts. Are you going to be for the plaintiff, or are you going to be for the defendant, or are you going to be, you don't know which one you're going to be from. And people can answer that. And if you ask the question on a graded scale, like, you know, from 1 to 10, you make them raise, you know, grade, if you can give them a little clicker where it goes on a computer. You can get a lot of good information about developing what they feel about things. So I think a lot of it you can flush out during voir dire. I think the argument was very effective. I mean, it was a great argument. What he did, brilliant. And that's fair too, totally fair. Although I've never really seen. I don't think. Have you ever seen a lawyer ask the jurors to raise their hand? I don't know whether that's permissible.
And this is the kind of thing, in my experience, that no one knows whether it's permissible except for the judge making a snap decision.
Yeah.
I mean, this is an area where judges just have complete discretion in court management, right?
Yeah, the raising the hand stuff is, I think you probably get an objection to that.
But you can do that in voir dire. So in a situation where you're allowed to ask questions at all, the evidence does also support using pre-commitment techniques, getting the juries to agree, for example, if the evidence supported it, could you award $5 million to an average person from the community? That's actually a fair voir dire question, because if they're not even willing to make a big award, that means they're not willing to follow the court's instructions or decide the case according to the evidence. So that's a perfectly fair award. But you've also placed an anchor, and you've made them promise to keep their mind open at that level. Of course, it's a contingent promise. The evidence has to really support it in the jury instruction. But that sort of bargain in other settings has been shown to help change behavior.
To push a little bit more in this area as well, considering what we can do with juries to try to tease out some of their implicit biases, those same tools don't exactly exist with bench trials. When we can show that, say, judges suffer from similar types of implicit biases as juries, why would one biased fact finder be better than the other than perhaps we're able to manipulate the jury through deselection?
Well, I guess the thought, that's a good question.
Thank you.
The Seventh Amendment and comparable state amendments give a degree of sanctity to facts found by a jury. The Seventh Amendment says it preserves the right to a jury trial, but it also says the jury's finding of fact shall not be disturbed by anyone else. So when a jury makes a fact finding, that's pretty difficult to get a court to overturn it. A judge who's finding facts, on the other hand, does not enjoy that constitutional protection of not having his decision. Now, yeah, I mean, they're appellate kind of principles to say you give a lot of weight to the judge when he sits as a fact finder, his decision. You know, it's got to be clearly erroneous or something like that. But I think the appellate courts give a lot more deference to juries, as they should, than they do to judges. So that's one thing. It's easier to attack a biased judge's ruling than it is to attack a biased jury's ruling, in some ways. But I don't know.
I'll suggest two other ways that juries can be less biased. One is the rules of evidence can sometimes protect juries from receiving biasing information that a judge would receive. For example, I had a client once that had previously had an illicit drug habit. Had nothing to do with the case that we were now bringing, a products liability case. Because it had nothing to do with it, is legally irrelevant, and we succeeded in a motion in limine in preventing it from even being introduced. It had been discussed at deposition, of course, because the rules of deposition are different, but we were able to draw a line and keep that fact out of the trial itself, and I think that helped prevent the jury from being biased by it, even though, of course, the judge had to know it for us to even make that motion in limine. So that's an example of a blinding technique that I think is one of the main motivations of the rules of evidence, is to prevent the fact finder. And so I think in bench trials, the rules of evidence are kind of a joke because you actually cannot prevent bias, and telling the evidence, the psychological evidence shows that a judge telling himself to ignore X doesn't help him ignore it. The judge telling a jury to ignore X doesn't really help them ignore it. In fact, it can have the opposite effect. It can add attention to something. So if I say, don't pay attention to my blue and white striped tie, now everyone probably is thinking about it, which they otherwise wouldn't have. So that's one way, is the rules of evidence can actually blind a decision maker from receiving biasing information. And I think the other is deliberation. Having other people in the room call you out on a biasing factor can matter. It can matter in an extreme sense. For example, there's a case decided just within the last month where they actually nullified a jury decision because of overt race bias. So on that extreme level, but even short of that, and merely through the deliberation process, saying, hey, no, that's not the way we're going to decide. We're going to decide it based on the facts presented, just like we promised the judge. And the research shows that jurors take the rules very seriously. I mean, they understand that life or death hangs in the balance, or huge sums of money. And so they call each other out. It's not infallible. It's still a human process. But this is a case where many minds are better than one, I think.
And it's also just sitting at the table in the deliberation, sitting with different types of people are going to counteract some of that, just like you're saying. So in my previous example, if you have skinny people and fat people together, there's going to be, people are not going to say, this guy has no,
So here are two questions for you, Roy. Do you think when you question jurors in the selection process, do you think they're more likely to be honest if the judge asks the question or if the lawyers ask the question?
Well, the problem you get with the judge is that the courtroom is one of the last places in American society where you have a very strong authority figure in your face, right? There's nowhere where we stand up for somebody. You don't stand up for the CEO of your company, etc. And when the judge asks you something directly, can you be fair and impartial, like you're saying, it's not only it's socially desirable, it's something that the judge is making it clear to you what the right answer is, and you want to please the judge and you want to please yourself. I'm the kind of person who would be fair and impartial. So it's difficult under that heated situation to give some real variation of answers directly to a judge. Now, on the other hand, even with a lawyer, you're in this heated situation. You've never been in it before, or it's been years, and it's hard to sort of be honest in a group of people, right? So either way, you're having trouble of is people just being socially desirable, are people making socially desirable answers to themselves, etc. But there are pluses and minuses of both. But,
I think it's interesting. I mean, it's interesting how all these roles evolve. So when at the time of the Seventh Amendment, 1791, the juries decided both law and fact, and juries were permitted to nullify. If they wanted to nullify, they could nullify. And in the last 250 years, we have witnessed judges taking away power from jurors. I mean, they don't trust jurors, and so they grab the power. They say, no, you can only decide facts. I'm going to decide the law. And you've got to, and I'm only going to let you hear certain facts. All these rules of evidence have, grown up to make sure that the jurors truly are a black, an empty slate at the beginning of the trial, which is not the way it used to be. The reason we have jurors is the king couldn't afford judges. So they let people in the community who they got for free to come in, and jurors were the judicial system. And because they didn't have to pay them. And they figured people in the community would know things about property rights and who committed a crime and who was sleeping with someone else's spouse. And, they'd know everything about what's going on, and they would be educated. Now, if you know anything about the case, you're struck. You can't be on a jury. So that has totally changed. And even in my practice, my 50 years of being a trial lawyer, when I began trying cases, voir dire used to be the time you argued your case. I mean, there were lawyers that taught you win or lose the case in voir dire, because you could make an argument. You would argue the case like crazy, and you had unlimited time. And you could, if you hadn't decided, got the jury on your side before the jury selection, you would lose. And the federal judges hated that, and they took away almost all the power for a while from lawyers even asking questions. They thought it was a waste of time, it was an invasion of privacy, and they thought that we lawyers were abusing the system, you know. So they said, you're not going to do it anymore. We'll do it for you. And then it came to the point where the judges were doing it in such a perfunctory, you know, way, in such a, you know, in 10 minutes the jury will be selected. The judge would, can you be fair? Okay, you're good, go. And now the pendulum swinging back. Even in federal court now, I would say probably a good third of federal judges are allowing the lawyers to ask them to participate in voir dire, to have 15 minutes, 30 minutes aside to ask questions. So we're seeing that whole movement back to allowing the lawyers to ask some questions. And I agree with Roy that I think you get a better it's better in selecting, rooting out bias to let the lawyers participate. So here's a second question for you. And we're facing this right now. There are a couple of judges in the country who we have learned are requiring the lawyers to make their full opening statement to the entire venire, 60 or 70 people sitting in the courtroom, before voir dire, before jury selection. And, the lawyers are kind of indifferent to what they do because you're going to make the opening statement either on Tuesday morning after you got 12 in the box or on Monday morning when you got 60 sitting down in the courtroom. Same opening statement, basically. So the question becomes, how does that affect the jury's answers to the questions? Does it improve their responses and improve the ability of voir dire to get an unbiased, fair jury? Or does it not do that? What do you think about that, Roy?
Well, it's something we'd have to do more of to really get a sense of where it really plays out. The downside of it, the positive side of it is you get more informed jurors who can answer the questions in a more informed way. And just as a side note, the more you get away from the federal court, demographic questions, the more you're getting away from some of the just sort of racial biases and stuff. The more information you have, the more you can work with, means that you're not just going, I don't want black people, I don't want Spanish people, whatever. Now, the positive side is you get more educated jurors. The negative side, I would think, is that you get a certain subgroup of jurors who game the system and go, this is my way to get out of jury service, right? We already see that. You already see people going, oh, I just couldn't be, sort of gleaning what the case is about and going, I just couldn't be fair on that. And they go, really? You really couldn't be? Oh, no, I just couldn't be impartial. So you lose a few people that way. If you give them more information, would you see more of that? Does it matter? Well, we don't know.
I think I'm going to use that to bring us to the next slide, which is that idea that, as Steve was mentioning, jurors really are just people pulled from the community. A lot of them don't want to be there. One of the TV magics that Dr. Bull possesses is that he can essentially read minds. So let's see that in action and the way that maybe some people experience jury service.
Did you have a good relationship with your daughter?
After my divorce, especially, she would talk to me about everything. She would tell me that I was the only one who really understood her. She would talk to me
My
about...
wife used to pull this, riding to the defense of the children. She had to control everything.
She said that she really liked Brandon.
These kids in a divorce are just lost.
Really hit it off. I know she wanted to sleep with him.
And did they sleep together?
She was 18. It's normal at the age to meet a boy.
It's normal to meet a boy and drown?
Did you hear back from Mr. Peters?
Not till 2 days later. I got a call from his assistant to tell me that there had been an accident.
His assistant called you, not Mr. Peters.
They did a head count. They thought she might have fallen off the boat.
Somebody needs to stick it to this prick.
Call you to tell you your daughter was dead.
Objection.
Sustained.
No further questions.
Ms. Yang, did you know your daughter was a drug dealer?
It's not true.
Mrs. Yang, you might learn things in court today.
I just don't like this lawyer. I don't like the way he talks down to me. And did you see the way he makes his associate carry all the bags?
Methylene dioxymethamphetamine.
I'm so hungover.
MDMA.
I'm so hungover. So that might actually be a realistic, I would think, in some sense, portrayal of how some people experience juries. They are lay people that may be bored, confused, feel righteous, feel any number of emotions with being put into a situation and forced to look at the same lawyer who they think is a jerk or be hungover. And that's because they're a group of lay people, and that is both probably in some people's minds the biggest weakness of juries, and in other people's minds the greatest strength of juries. So I was wondering if the panelists could talk a little bit about how these realities affect, both undermine the jury's effectiveness and enhance the jury's effectiveness.
Could I just agree with the premise if I edited out the word lay? Jurors are people, and so they have distractions and boredoms and hangovers, but of course so do judges, right? Judges may not like the lawyer presenting the case. They might have had a bit too much to drink the night before, et cetera, et cetera. So I think what we're calling out is just the fact that jurors are humans. And it reminds me of Churchill's old maxim that, you know, democracy is the worst system except for all the others. And so when we're ready to have Watson decide our cases, you know, IBM's AI, we could have that conversation. But until then, you know, sending a judge to law school and putting some black robes on him doesn't eliminate these same human frailties.
Yeah, I think that your human reactions as a member of the community is what you're there for and what we like. That's the fact that jurors get bored means that lawyers have to be better to lay out their case in a more compelling way.
Well, perhaps it's not just the boredom, but maybe in technically complex cases, let's say, or areas where the evidence might be somewhat confusing. That could drive them towards boredom or drive them more towards confusion or erroneous verdicts.
So, yeah, I mean, we have seen when the Civil Jury Project is going around the country having these lunches to which we invite judges and lawyers and people who served on the jury in the last few months who have deliberated on a jury and returned a verdict and come to lunch. And they are on panel discussions and they tell us about their experience. Well, the thing that everyone hates most, besides parking, having to pay for parking, is lawyers repeating themselves. That's the biggest complaint they have is, I got it. We got it in 2 days. It didn't have to go on for a week or 2 weeks.
It's funny, my student evaluations say the same thing.
Well, which is fair. And the problem that the lawyer has is in jurisdictions where they don't allow the jury to ask questions, where they allow the jury to ask questions of witnesses, not orally, but in writing. You do get a feeling frequently whether you're getting through or not. You know, it's not, and where you don't have any feedback at all from jurors, they're just sitting there not talking like here, but couldn't do that, obviously. The lawyers are getting it's a one-way conversation. I mean, it's a one-way thing, which is unlike class, totally unlike class. You're getting feedback. You know when you're getting it across, when they're unhappy. You really can't figure that out trying a case. So we are taught that the way you teach people and the way you convince people is you repeat yourself. Repetition, repetition, which turns out to be the thing that they hate the worst. And so if we could figure out a way to figure out what they are thinking, what is concerning them, get feedback from them as we are going, that might make for better trials, not worse trials. And that's one of the things we are talking about, trying to get better trials, because you never get anything like this. He does something, you know, so, and I'd ask Roy this. Bull has these, I think he calls them mirror jurors.
Yes.
Okay. He finds people who have, in the community, who have the exact profiles. Now, we call them shadow juries, where you go actually, you know, I mean, he gets one for everyone on the bench. I mean, everyone who's in the box, he gets there are 12 on the jury, he's got 12 mirrors. I exactly don't know where they are when they're watching this or getting this, but somehow he finds out. So he knows in real time by looking at the shadow juries who his clients have already convinced. He knows who needs to be convinced. We don't. I've never had that. I mean, it'd be interesting.
Well, yeah. I mean, it's a bullism basically.
Yeah.
You'll be surprised to know that I also can't read minds as well as Bull, but close. But so there's a thing called a shadow jury, which is usually you take maybe 4 or 5 people, you have them sort of sit in the pews and watch the trial, and every night you interview them. What do you think? Where are you going? What do you think? Which way are you leaning? No. What Bull does is different. He calls it a mirror jury, which apparently is a Dr. Philism that comes from wherever. But his mirror jury would be so profoundly expensive also that he goes, how am I going to match Steve Sussman? I got to find a guy who has the exact same career, the exact same hobbies, and then when they talk to him, you'll see on the show they go, oh, we lost juror number 12, right? So juror number 12, who's supposed to be Steve, goes, oh, now I'm not with you. Oh, well, how are we going to bring him back? So that's a little outlandish, but there is now an increased use of shadow juries because you can now often film, like have a live feed from court. So you don't see the shadow jury sitting in the pews. They sit in some law firm or a hotel room and watch from afar.
Where can you have a live feed?
It is sometimes in a big trial with a lot of.
In some states, they actually now have open live courthouses, even if you don't have to make a special request. But the biggest conceit of what Bull's doing is the notion that for a 54-year-old black iron worker on the jury, if you find another 54-year-old black iron worker, they usually even have the similar haircuts or equally overweight and stuff, that those two will decide the case alike. And that's just not what any data supports. It goes back to this old idea that demographics are everything. People are so complex in the narratives they create and in the things that matter to them that I think that's the silliest concern, that there is a mirror.
Well, okay, I'm not sure I totally agree with that, Chris, because let's say we frequently have, because the trials are disappearing, what trial lawyers are doing now is they're participating in arbitrations. And arbitrations are usually before a single judge who is hired and who you know a lot about. They work for JAMS or AAA or something, so you can figure out a lot about who these people are. And they've usually had a career, and you can identify who they are. I am frequently using Roy jury consultants now. My firm is. We have a substantial case before an arbitrator. We try to find a lawyer or former judge who is with JAMS or AAA and put on a mock arbitration or mock argument using someone who has this is not a jury. We're trying to profile the judge.
Right.
And get someone to hear the case that's very much like the judge. I have found that pretty helpful. It's pretty helpful. They're hitting you with the same kind of questions you might get from the arbitrator now. And
but it is a little easier to match legal thinking to legal thinking.
Yes, that's true.
You've got a lot of data about both people that you can cover, but just on age, career, race, gender,
relationship to mom.
Well, that's just we're going to get there. You can do that with dating now. Aren't there dating services that I put in some biographical stuff on me and they fix me up with a person who I want to date who has already been, they put in their biography, the computer matches you up.
Yeah.
So you have a database of people in your group, in your Rolodex, who match, and you go, the minute a jury is selected, you go get the appropriate shadow jury by putting in the details. It seems to me to be
the flaw in it is in the very first episode here of Bull, they did this, and they had a female juror who had some relationship with his son or something, and they messed with how the person, the witness, testified so that it would mirror basically her relationship with her son, which Lord knows how they figured it out.
No, what wasn't the episode where two of the jurors, he saw two of the jurors were a man and a woman were like being friendly at the breaks.
Yes.
And then he figured out they were maybe having an affair or seeing each other or something like that.
Right.
So he gets two mock jurors to do the same. It was pretty interesting.
He went out of his way to have them couple up because he thought it was necessary for the science.
But you know, so all these things, I mean, the thing about Bull is it's totally crazy. It's science fiction. And there's something in it that's kind of truthful. For example, Richard and I were in Corpus Christi, Texas last Friday, and we had a panel of 8 former jurors. 3 of the jurors had been on the same jury. And we discovered the guy who was the most vocal, who was a foreman of the jury, was a school teacher. On the jury were 2 of his students. And they the lawyers never found that out, okay? I mean, the questioning was so perfunctory. And I forget to ask that question sometimes. But, I mean, in a big place like New York or Houston or Dallas, you figure, how likely is it that one of the 12, 15 people are going to know each other? But if you're a lawyer, that's one of the first questions. That's back high on my list of questions to ask. Do you know anyone else in the room at all? Because you can see what happens. There was clearly, they thought we were getting 3 jurors. They got 1 juror. The teacher was clearly, in the foreman was clearly deciding the case. The others were just furniture. But there's an example of the relationship that you need to ask about.
So I'm going to move it on to the last clip that we have here. And I'm glad that Roy mentioned Dr. Phil. Some people may not know this, but Dr. Phil of Dr. Phil fame is the executive director, or rather executive producer of the Bull program, because in his former career, he was a trial consultant back in the 80s. And he's had, it's unclear, but it seems like he's had a pretty heavy hand in the show. And so this next clip features a little bit of Dr. Phil as well as a clip from the show.
You can do this.
They're not gonna believe me.
Hey, don't give up on people. They're all we've got.
The scene we saw earlier, don't give up on people. They're all we've got. I mean, Bull trust juries, which I love.
Well, yes, and you know, that definitely comes from my value system, because, you know, I've always said that I think the average jury has at least a 1,200 IQ. Because even if you've just got 12 people with an average IQ in there, collectively, they get it. They're really smart. And I am a huge fan of the jury system. And I believe that juries, in the main, get it right. And if they get something wrong and you trace it back, it's generally because somebody else made a mistake. It's either they got the wrong definition from the bench, they got the wrong instruction or definition in the jury charge. But if you leave it to their common sense, if you leave it to their problem-solving skills, a jury's going to get it right 99 out of 100 times. I am a huge fan of the jury system.
Yeah, well, I appreciate that. I am too.
So I want to make sure that we have some time for questions from the audience. But one of the things that is brought up in that closing comments is this idea that juries get the answer right. And yet so often we hear about outlandish jury verdicts, let's say, where people think that the jury's just giving out free money. We know those are actually the outliers in these situations, but what is driving that misconception? If data suggests that juries are adequate fact finders, they're capable in doing their job, what's driving this misconception that they're handing out money?
Chris?
Well, I mean, to some degree, you have to look at the political economy of lobbying and that sort of thing. And so when you see tort reform happening in the states to try to take power away from the juries, capping damages, which prevents their discretion, and other efforts. I think this is partly caused by particular lobbies that are invested in doing this. And this goes back 30 years to the tort war battles, maybe more than that, but there was a whole trend around judicial hellholes and U.S. Chamber of Commerce. And so part of this is just very effective propaganda that has carried the day in certain debates. And I think there's a sense in which the companies are repeat players in a way that individual plaintiffs aren't. And I think for quite a while the debate was lopsided in that way. So I think that's one cause, is just the old story about money and politics and the press.
Yeah, I totally agree with that. I mean, you say 30 years ago, it's exactly 30 years ago. We know by looking at the statistics that the trials in this country increased from 62 to the trials per judge, at least, was on a pretty high, steady increase from 62 to 86. And in 86, it began dropping like a stone. And so what happened in 1986 that caused it to begin dropping a stone? Well, it was 6 years after the election of Reagan, who began the tort reform. The lawyers are bad, litigation's bad, lawsuits are bad for the country and the economy. 1986 was the year that the American Tort Reform Association was established, incorporated in Washington, D.C. 86 was the year that the Supreme Court announced its summary judgment trilogy, making it easier for defendants to get out of a case by convincing the judge, well, the case was just not plausible. And it was all based on appealing to judges who were not real trial lawyers, and many of whom we've hit on the idea that there's so many people on the Supreme Court and appellate courts have never tried a case, certainly never before a jury. And they began feeling that, we need to screen these cases so that the only thing that a jury goes to a jury are the creme de la creme of cases. I mean, the plaintiff, by the time he gets a civil case to the jury, has met some minimum threshold of showing that he has a merit case with merit. It's enhanced pleading, summary judgment. You don't get an expert witness unless you prove his testimony. Prove to the judge the testimony is reliable. So all these screens that keep out cases. And clearly, and then at the same time they were doing that, they were the Chamber of Commerce Business Roundtable was on this propaganda war, getting what they thought were the coffee case, the BMW paint job case. There were all of these cases that they got of examples of, quote, runaway verdicts. And they were very persuasive and then they convinced the public. I had a very interesting conversation the other night with a guy who's here in New York named Philip Howard, who's a very prominent lawyer at Covington, who writes this book on common sense or uncommon sense or something like that. But he argues that, it's not fair to make people subject to liability on what a jury thinks is reasonable behavior. And I kept telling him that's the best way to determine what's reasonable or not, by asking 12 people across section of the community. But he thinks it's unfair. He thinks his view is very strong. There should be rules. You should know what the rules are. And he's got all kinds of examples. And frankly, he's got better examples than I do. I mean, examples that really make sense. And his examples were, there are teachers at schools now that if a child feels bad or is bullied, the teachers won't even hug them, put their arm around them, because they'll be sued right away. I mean, all kinds of horror stories. It's the doctors that will not do the proper thing because of fear of being sued for malpractice. And so, I mean, it's that kind of scare job that has gone out that we have to somehow regain the high ground by convincing people that, you got a better shot with a jury. 12 people are much more likely to get it right than a single person, period. And I think that's, so I think we can do that.
All right, I think that wraps up all the clips that I have of Dr. Bull. We would appreciate your questions. If you have any, we have mics set up to the right and left. You can direct questions to us. Yeah, absolutely.
Just picking up where Mr. Stussman just left off, about the single decision maker. How come we haven't been able to influence people to the extent to make them understand that it's much more easy to interfere with a single decision maker, a single arbitrator or a single judge? Judge, he or she may be sitting there for 20 years. It's easier for someone to manipulate that person than it is a random group of 12 people just showing up. There are people who manipulate judges, and we have basically no screening, really, of the behavior of arbitrators. Is there something that we could play off there to sort of let the public know, or start a theme of, hey, a judge could be influenced a lot easier than a random group of 12? Certainly an arbitrator can. There's no mechanism really to monitor their behavior.
I don't worry. Well, first place, there is a large group. I'm not so fearful about an arbitrator being crooked or being influenced or being bribed or anything like that. I don't really worry about that. I mean, I guess you would if you were a plaintiff, represent a plaintiff on a consumer contract where the big company that you're suing in arbitration making a claim uses the same arbitrator over and over again. Repeat business. So yeah, I'd be concerned there. Normally, I think there's something to be said for the two parties can pick a better judge. I mean, we pick someone together, usually in arbitration, in a big case. And you can make a better pick of a judge than you're going to get at random at the courthouse if you go down to the state courthouse here in New York, or even the federal courthouse. You can get a more qualified person who's actually tried a case. And I think that's true, but you pay a big price for that. You're paying $750, $800 an hour for that judge. So I do think that's true. I think what is moving people a lot away from arbitration is that arbitration, remember, an arbitrator's decision is normally non-appealable. It's final. And that's not true. Even a jury's verdict can be set aside. A new trial can be granted. A judge that makes a mistake. And so I think the problem, and if I look at the data correctly, which is something I never knew when I set up this jury project, bench trials have disappeared faster than jury trials. So that would tell you something about the common objections to jury trials, that it's too expensive and that the result is too uncertain. Well, bench trials apparently have the same problem. I do think they are just as expensive, and I do think the result is just as uncertain because you don't know what judge you're going to get in advance. But so I think the real movement is not from jury to bench in the public courthouse, but from public dispute resolution to private dispute resolution. That's where people are going because they think they can do it. One, confident, it's not on the public record, which is true. Our courthouses are open. That's something we cannot do anything about. And the second thing is that they can pick their own person. I think we fight back with the notion, and the reason why general counsel are disliking arbitration now is they know it's not less expensive, and they worry about not having appellate rights. And they want that right to appeal if something crazy happens. And so they are now, Richard and I, with the civil jury, just finished a project where we analyze business-to-business contracts, which are the ones that are material by definition, that are filed by public companies in 8Ks with the SEC. We looked at the first 6 months of 2016. So here are contracts between big businesses, and we figure if there was ever an opportunity for a corporate America to speak, they would be inserting jury waivers or arbitration provisions in these contracts. And we found, to our surprise, that 53% of the contracts do not have either a jury waiver or an arbitration clause, which means that someone out there who could have put a clause like that in a contract made a decision not to. That they do not want their disputes resolved in private or by someone other than a judge and a jury. So now we are in the process of trying to identify who those people are and contacting them. They will be good, testimonials, I think, for the power of having jury trials and keeping them. But that's, to me, the answer. I mean, I think, we need to convince them that you should use the public courtroom because it doesn't cost you anything, because there are all kinds of appellate protections, because the rules, there is stare decisis, where you can look in the books and figure out what the result should be. You can't do that with arbitration. Nothing's published. And kind of have arguments why people should be resolving their disputes in public courthouses.
Do we have another question?
Thank you. When you say juries get it right, I sort of apply that to getting the facts right, particularly in a criminal case. I never really thought of it in terms of getting the numbers right, the proper amount of compensatory damages. And I wonder, maybe you can correct me, do you think that term applies to both, doing the number calculations and or the facts? I mean, yes, it's easier to get one person to exaggerate numbers, but the idea that out of 12, there'll be a reasonable one, maybe it's more likely than not. I just wonder if you...
Chris, I think some of your research touches on that.
Yeah, so whenever you say they get it right, you need analytically some sort of lodestar to say what the truth is. And the interesting thing about these cases is we put them to juries just because there's a genuine dispute of material fact, right? So as a researcher or as a philosopher, we can chase our tail around in circles. And so one lodestar we can look at is, well, what would a judge do? And there was a classic there's a classic experiment now 50 years ago where they asked a series of judges, I think it was in Chicago courts, to write down their own judgment in secret when there were bench trials. And so we have this data of, I don't remember, several hundred cases that were decided by a jury, but where the judge... Was it 4,000? Wow. It's been a while since I read it. And what was interesting in the study is you saw a huge correlation, that the judges, the shadow judge verdict and the actual jury verdicts tracked very closely together. So again, what's the right? Maybe they were both wrong in every case. Maybe they were right in every case. We don't know. But at least we know judges and juries decide fairly similarly. There's been some follow-up research that suggests similar.
So I think it's the research you refers to, which was done in the 60s. Yeah. Calvin Zeisel, based upon trials which occurred in the 50s, what it basically said was that judges and jurors agreed in about 65% on the result. So it was a number that all the academics have been comfortable with. If it had been a higher percentage of agreement, juries would be superfluous and would support their argument, why do we need juries? If it had been a lower percentage of agreement, people would have said, juries get it wrong. we can't trust juries. So there's some sweet spot there where it's good for juries. It's a good argument for juries. What they did find was that on the damage number, juries typically awarded 20% more than judges. I believe if that research was done today, you would get a different result entirely. And that's because the tort reform movement has so colored the average person's thinking about what do you deserve for an injury in an automobile accident, or a bad drug, or a bad business deal. That judges around the country tell me that their jurors are awarding less money than they would have awarded. And as a result, it's amazing to me. As a result, insurance companies who are defending cases prefer jury trials to bench trials today. That they think that, for example, in a medical malpractice case, juries are much more frugal and, they'll award you the medical, but they're not going to warrant anything for pain and suffering and that kind of stuff. I mean, it's interesting.
I'll just add two other data pieces of that. The data suggests that when juries deliberate, they end up at a value that's around the median juror's individual vote. So the deliberation does have the effect of reducing the outliers. They sometimes skew a little higher, but it's still towards the middle. And the other piece is that we know juries make compromise judgments, and one reason they're probably awarding less than the judge is the judge might be better at insulating, okay, yes or no to liability, than if liability, award full damages. But we know that juries as a group instead compromise. So the 4 people that said, no liability here at all, they end up pulling down the actual award. So you end up with maybe less than the judge would have awarded.
Thank you. We have another question.
Have you done any studies or seen any studies that compare the outcome of arbitration versus either a bench trial or a jury trial, and whether you believe you sort of come out the same way? If you went to arbitration and you had a big arbitration, you would feel you sort of came out as you would if you went to court.
No, because, and I've never heard of it being done, Louis, because the arbitration results are almost always confidential. That's the problem. You can't get any numbers. I don't know where you could get them. I think that now maybe certain kinds of arbitrations, maybe FINRA arbitrations, publish results or something. I don't know. Maybe there may be some groups that do publish the results. My personal view is that arbitrators are much more likely to split the baby than judges or juries. That they are, after all, people who are deciding cases, and they are paid by both sides. They want to usually, where they're two big companies hiring them, they want to be hired again. They don't want to do anything extreme that would keep them from being hired again. They're being hired, they know they're being hired because they can be depended upon to be moderate. Mm-hmm. And so they are essentially splitting the baby in a lot of cases. So that, I think, is, that's why I don't like arbitration, because I know that I'm fearful that that's what all these arbitrators are doing. They're not, even if my client is right on liability, they're not giving me a full compensatory damages, because they don't want to hurt the company on the other side too much. They want to be hired next month in a different case.
Are there any other questions? All right, well, that wraps us up just right about on time. We have some wine and cheese that we welcome you to enjoy, and thank you for coming out.